Let's talk mediation. Greetings, everyone, and welcome to the conversation series on mediation, created with an aim and vision to promote awareness of mediation in the world around us and to talk about mediation and other alternative dispute resolution solutions from the perspective of a common person. We continue with a short legal disclaimer. The views expressed herein are the voluntary, personal perspectives of the speakers and may or may not represent the views of the larger professional community they belong to. The conversation series aims to provide a general overview and awareness on the subject matter involved and may not be construed as a legal or professional advice in any manner whatsoever. This session is being recorded for wide circulation. Let me introduce the main speaker and the guest panelists for today's session on role of advocates in mediation. We have Mr. Ty Bodoni. Welcome, Ty. Upon
Thank you.
graduating from Florida Barry's University School of Law in 2010, Mr. Bodoni served as a staff mediator for the 9th Judicial Circuit's Dispute Resolution Department in Osceola County Courthouse. I hope I have pronounced that correctly.
Perfect.
He is now in private practice as a professional mediator and arbitrator and works on family insurance, personal injury, property, HOA, foreclosure, civil, business, agriculture, and other related cases, having mediated and arbitrated over 3,500. That's two. Family, county, and circuit level cases. Ty is the director, senior mediator, and primary mediation trainer for the Mediation Center of Central Florida, whose mission is to make mediation and mediator certification courses as well as CME and CLE recertification training affordable and accessible for all Florida residents, law students, and attorney mediators. Ty also sits on a
Thank you so
number
much.
of mediation panels throughout Florida, including the Florida Department of Financial Services, the Florida Department of Agriculture, Florida's Better Business Bureau, as well as both the Orange and Hillsborough County residential mortgage foreclosure programs. So, welcome, Ty. I was really impressed by 3,500 cases. I never knew that.
Well, when you do it every day at the staff mediator, it adds up really, really fast, to be quite
Yes.
honest with you.
So we
You know,
welcome on board. As guest panelists, we have Mr. Vishal Subhas. Vishal is a founder of LBS Legal and a young dynamic lawyer who promotes legal awareness on Instagram as @lawyer Vishal Subhas. Expert in conflict management, mediation, and negotiation with a focus on business and real estate disputes, delivering peaceful resolutions online in India. He is a mediator who specializes in conflict management and alternative dispute resolution. With his passion and expertise in ADR, real estate, and business law, Vishal has been assisting people in resolving real estate and commercial disputes through mediation and negotiation in Bangalore and Chennai for the last 3 years. Welcome on board, Vishal. It's a pleasure to have you here.
Thank you so much, Sunil.
Ms. Reena Chaudhary, a mediator and a student at Army Law College, Pune. She is practicing at APARADRC. She has also judged an international mediation tournament, NLIU Bhopal 2022, and has been invited to judge the CPR International Mediation Tournament in Sao Paulo, Brazil. She is a mediator and wants to work for the community mediation so that she can help the people resolve their disputes without paying for it. That's very noble. She aspires to be a practicing professional in the field of ADR and give all that she can do to promote it among the youth. Welcome on board, Nina. It's a pleasure to have you here with us.
Thank you so much, Sunil, for having me.
love it. Our
So,
future superhero. Yes, I love
yes,
that. That's
yes,
great.
most definitely, yes. And it's a privilege to have younger generation on board talking to us. So, Ty, I will ask you first of all, because you have been in the field of mediation and you are doing it so very well in Florida. When we talk about the role of advocates in mediation, what it means to a mediator, to the mediation, and the role of advocate can be best described by you people because you have the laws also well pronounced for a mediator. So over to you, Chai. What is the role of a mediator from the perspective of a common person?
Ooh, so luckily now, mediation is well entrenched, right? Here in the States, particularly Florida is probably one of the leaders, California, New York, and other states as well. But there were advocates early on, 30 years ago, who understood the role that mediation can play, um, in the community as well as within the law for judicial economy alone, right? Mediation, for instance, in family law here in Florida, has become a mandatory part of the process, so that once a case is filed, if there are minor children or property in controversy between the parties who are divorcing, they must attend mediation. And what's the impact that that has had? So, for instance, when I was the staff mediator, we kept statistics, and it was 74, 75% ish of the cases were actually settled to some extent, if not entirely, at mediation. Can you imagine the impact that has on judicial economy, on the docket, on the cases that no longer have to go in front of the judge? And so, while I would tell you in the beginning, everybody here the legal community was skeptical about mediation as well. The legal community does not like change. It doesn't sit well for them.
Yes.
The judiciary, we're used to standards of practice. We're used to time honored, traditions. Zoom, for instance, right? Before the pandemic, how many mediations were handled virtually? Not many. Maybe telephonically because there was a good reason. Then the pandemic hit, and we were forced to adopt, this platform, and it has changed everything from the perspective of a mediator, right? My practice has changed drastically in a good way. The pandemic had a really good effect, right? What I mean to say by that analogy is, it was that change was forced upon the ADR, for instance, and the courts in large part. And that change happened overnight. But had it not been for for the pandemic, how long would it have taken for virtual mediation to have taken hold? So, so if we look at the legal community just in Florida, um, unless something would have happened, it took 30 years, right, for mediation to become a standard. I would tell you that over time, the judiciary, while they were skeptical initially, over time they have seen the benefits of mediation, not just on the court docket, but in the community as well. Mediation works, right? And but it just takes time for everyone to kind of see it. They're going to be skeptical in the beginning, but what I love is that Reina is here, right? And so if you believe in, as a young person who's just entering, if you're an advocate and others are an advocate, if you're talking about it and I'm talking about it and Vishal is talking about it and Sonal is talking about it, it's starting already to get to become a part of the legal community over there. You just need to keep on doing it. So now you need to keep doing this. And Vishal, you need to continue that practice. And before you know it, there will be more. And Reina is right behind you. And she's standing on your shoulders, right? And I stand on the shoulders of all who came before me. Keep the faith, keep on plugging away, and and it can have a great impact on the community. And when the judiciary sees it, they will likewise begin to adopt it. I have full faith, without knowing all the specifics and what's going on. I have full faith that it will happen, because why are the three of you here? Why do you believe in it? everyone will see your zeal and your zest, right? And it works. And let me stop myself because I could keep going and going and going and going.
Yes. So basically, I wanted to ask you when practically you are into mediation, and like in our talks or in our roundtables also, you have also talked about pro se parties. So what are pro se parties? Uh, because it's a new term for India. Like you would remember, I was like I asked you, Ty, what does that mean? What is a pro se? So so you explained that to me. So now it's time to. So it's a new term for us. So what does pro
That's
se
true.
party means,
Yes.
and why it is such a scary thing for mediators out there? You know that you always say that you have to be very careful about pro se parties. So what are pro se parties?
Unrepresented individuals, people who don't have the benefit of either yourself or Vishal representing them in court, right? And let's be honest, most folks, regular folks, who has money to spend on an attorney, you find it, but it's tough. And then in the one of the worst times of your life, now you have to spend more money when you have less money because of what's going on. um and most folks have, they have whatever jobs that they have, but why would they want to know about the things that need to know about when you go to court? But when you go to court, you need someone, I mean, to really get the best outcome. If it helps if you have someone who knows what they're doing, who does it every day in the form of an attorney. But the reality of the matter is, many individuals, for one reason or another, they have a legal issue, whether it is a civil matter, or whether it is a family matter, a divorce or something of that nature, and they find themselves in this really tough position, and they just don't have the ability to get someone to represent them, and so they wind up going to court on their own, and we call them a pro se party, which is in essence an unrepresented party, right? So what is so what Sanal is saying, when I talk to when we train and when I talk in general, you have to be very careful with pro se parties, with unrepresented individuals, just because they don't know what the law is, just because they haven't, the, we for here, we are working in and around these circles. We understand the terminology, we understand the terms of art, we're familiar with the law. We're not that, I mean, don't get me wrong, I'm still nervous before a mediation starts for any one of a number of reasons, but I'm not going to be as nervous as they're going to be, one, and two, because they don't understand the law sometimes, and that's not their fault, they just haven't been around it, so it they may not hear you the right way, or you also have so many different kinds of personalities, and they will most folks are wonderful individuals, of course, but every once in a while you get unique individuals who will misrepresent or take you out of context or get really very emotional, and can become a bit problematic with unrepresented parties. Also, as a mediator, we can't we can't give legal advice, right? If I hire yourself or Vishal as an attorney, I'm looking to you to tell me what to do because I don't know what to do. And when they come to us in mediation, what are they're looking to us to tell them what to do. And so we have to help guide them without giving them legal advice. And that is not easy. It takes practice, and it's like being on a tightrope, it's a precarious balancing act, because you don't want to give them legal advice and you also don't want to coerce them. So it's that balance of helping them from being very nervous and not knowing how they should react, and or what they should agree to in mediation, to helping them come to agreement. It will take a little bit of time. You have to have patience, with them, and the way you explain a legal concept it's not that easy, because you don't want to give legal advice, but you want to help as well. So they just come with unique challenges, um, and but for the most part, you can help them, and you can make a difference, in their lives. Not everyone, but a large the majority of them, you really really can.
So let's talk to Vishal here. Vishal,
Yes.
you've been a mediator and also a lawyer, an advocate you are, and you're practicing in civil side on, I see your cases on, like you're on Facebook, you keep posting on real estate and all.
Yes, yes.
So I want to ask you that as real estate is, where laws are there, and what about mediation? Mediation tackles not the legal aspect of it, and law is there where like tenant, between the tenant and the landlord, there are certain rules and laws which have to be followed. So a mediator, if a mediator is not aware of those laws, and there are parties who are like in terms where Ty said pro se parties, right, unrepresented. Now, if there is no legal knowledge, especially in a country like India, where there are many laws, as far as you also keep posting, there are many laws which are not known to the general public, and they are important. So if
Agree.
there is a mediation and it happens, and unrepresented parties or pro se parties are there, what would be the stand of a mediator who might not be aware of the legal nuances? So is it easier for a mediator to conduct such mediation? What is your opinion about it?
My opinion about it is, so mediators who is not like, suppose it is a property dispute. Sometimes the parties themselves choose a party who is expertise in real estate and choose a mediator. If not, if not, that's when the role of advocates come. So advocates know their interest, the client's interest, and so they can but the only thing is, the advocate has to be in a collaborative mindset and not very adversarial. So that
Yes.
is very important. But if he's in if he but sometimes very good thing is to bring party to mediation itself. Advocates will play a very significant role, because in India, corporates know what is mediation, but how many individuals know there is something called mediation? So that's
Right.
when the role of advocate plays a very significant role. Even I have got many mediations through advocates,
Yes.
because advocates. So when a tenant has a dispute or a landlord has a dispute, the first person they call is an advocate, not a mediator. So it goes there. So the advocate decides whether to take it to litigation court or to mediation. So it's very important for the advocate to advise, first analyze what is the scenario, whether to take it adversarial, or if there is a possibility to resolve amicably, then why not try mediation? Now, since we don't have a mandatory mediation, uh, role of advocates play a very significant role in that, as a thing.
Okay. Okay. So Reena, when we talk about role of advocate, when both Ty and Vishal are telling us about the role of advocate, now uh, you are a mediator and you're a law student also as well. So like what I asked Vishal, when there is a mediation going on and the legal nuances are there, there is a legal that there are merits involved in that issue. Do you think it will pay good, first of all, if a mediator himself or herself is an advocate who knows the law, or he or she has somebody on board in on the mediation table who can help with the law? Because this is what I actually wanted to ask. Like, if the law, you cannot bypass the legal nuances. That's what I wanted. Like,
I wanted to just add on to that.
yeah, yeah.
So
That,
the mediator don't have to know real estate law or even the parties. then if they suppose they want to know the parties, we can always bring an expert into the mediation. So we can bring an expert for both of them as a common person who is expert in real estate law, as an expert, and then give them advice in general.
Yes, but the mediator, what I wanted to ask is the mediator should be aware that this is the line that we are, in the mediation process, we are deciding something, and this is where it can bypass the law, and so here a legal help or a legal issue is there, and we need help of a legal expert here. So to know that, like I would let's ask Reena here her opinion, and then we'll come back to Vishal and Ty. Yes, Reena.
Yes, Sonal. So, according to my knowledge, what I've seen and experienced till now, the role of the mediator and advocate mainly is a very specific role, and it is of great help to the parties and also the mediator. It is, according to me, it is not necessary that the mediator should have knowledge of law, of that specific law or any other. That is the part that the advocate plays in a mediation. The mediators and the parties can anytime and always clarify if they have a doubt that if it may surpass any legal uh, of that matter. So, and the advocates are there to protect the interests of the parties and guide them, because sometimes parties are in a flow of emotion, and they make decisions which are not bound to be made because they think emotionally, not uh, from their mind, and that's where the advocate catch hold of the process and helps the party to protect their interest. That's what I have to say about it.
Okay. See, Ty, here I'd ask your opinion also, because when we were discussing some real-time cases, especially in family courts, when you were discussing, and we did a role play also. Now there were issues where it came out that some things, if if the mediation is done in a particular fashion or something is accepted, which could go beyond the legal aspect of it, like you how do you manage that thing, that law could have been bypassed, and then it would be a miscarriage kind of a thing, although the parties are agreeing to something which is not in stricto sensu, I should say, the legal
Right,
the law as would be decided. So how do you
right.
manage that?
Great, great question. And by the way, I want to say, you'll forgive my regional ignorance as well, because when you first said advocate, I was thinking, oh, an advocate for mediation, of course, but an advocate is also a counselor and or an attorney, and so I realized, as I heard, oh, okay, we're talking about the role of the advocate, as in, the attorney in mediation as well.
In India,
Um,
we call
of course,
advocates.
yeah,
Attorney is not the term
right,
used, because I think
right.
their attorney is different, an advocate is
Mhm.
different.
Right.
There is a fine line, and forgive me, I don't remember, but there is a line there. I
Yeah.
think attorney has to take some bar exam or something, and he is not practicing in the court, if I understand right.
Well, an attorney does, yes, to be a litigator here in the States. You have to sit for the bar and you have to pass the bar, and then you can practice in the courthouse. Yes, but but what's interesting is, as I'm hearing you guys kind of talk about this, we have the same concerns here as well, right? And that is, um, so I would tell you that many mediators are both an advocate as well as a mediator, and the benefit of an advocate being a mediator is that the advocate does have an understanding of the law. And while the advocate's role as a mediator is not to advise the parties, it is so helpful when the mediator understands the law, because the mediator knows better questions to ask. The mediator advocate understands the implications. The mediator advocate understands what might happen in court. And so when you're dealing with parties, and it is very helpful when, as a mediator, you have an advocate on each side, because my worry goes down, because as Vishal, as you know, there, and Reina, as you also put it, there's someone there who's watching out for their interest, who's giving them legal advice. So the mediator's job is easier in some respects. Don't get me wrong. The because there's an advocate on each side, so sometimes now we're in an adversarial process, and so it can be, then it's just a different challenge for the mediator to help both sides, along with their attorneys, come to with their advocates, to come to agreement. But that challenges is what mediators do, right? But when the mediator is both advocate and mediator, they have a better ability sometimes to help the parties, because they really do have the inherent understanding of what's going on, what's being said on both sides, and they know how to play devil's advocate. They know how. So when I'm with one side or the other, when they're represented, counsel is going to be positional. That is, the advocate may be positional because they're doing their job for their client, of course. And so if I understand, the mediator understands what's inherently being spoken about from a legal perspective, if I'm experienced, I can anticipate, I can get an idea what's going to be said on the other side in response to what the position on this side is. And so when the mediator then can play devil's advocate, when the mediator can then reality check, it's quite helpful, right? And the mediator can also get an idea, how best the mediator advocate can get an idea, how best do I navigate this? Should I? Because sometimes advocates are positional when they're with their client, because that's their job, right? And sometimes you kind of hit a wall, and so sometimes I like to get the advocates together, just the mediator
I
and the
wanted you to
advocates,
say this. I really wanted
and they
you to
have
say
a different way of talking with each other than they do
when
when
the
they're in front
clients
of their
are not
clients, right?
there.
Right. And the mediator's job is to kind of, so what I love about being a mediator is mediation is not a science, it is an art form. Litigation is more science than it is art, although it can be artistic as well. Don't get me wrong. You can come up with creative arguments, of course, but as a mediator, it's a little different, because it goes to what you said. In the mediation, the parties, in essence, so long as they can agree, so long as they can come to, they can start to see this out of the box position that the mediator may help them arrive at, um, they can do things that would not be ordered in the court. When you're in court, when you go to court, there's a position on one side, there's a position on the other side, and then it's argued and the court will make a ruling. Now, the court is going to make a ruling based on what the law is. Whereas in mediation, you can do things if everyone is in agreement, and it's a voluntary agreement, and no one is being coerced, and everyone's right to self-determination has been honored, and everyone says, you know what, we do agree, this is what we'd like to do. That can be something other than what the court would rule, because the court will rule within the four corners of the law. Whereas in mediation, so for instance, what if in family law here in the States, if we're talking about property, things having to do other than with the minor children, if we're talking about property, they will tend to try and put the parties on equal footing, right? Equitable distribution means if there's a home, for instance, If the home is worth $100,000, the law will see both parties have an interest, an equal interest, and legally they're both entitled to $50,000. Now I'm just picking some numbers, but but it's not one for one, right? There's so many things that you have to cars, personal property, everything else that goes along with it, bank accounts, marital debts,
Yes.
all of those things, retirements, anything, any assets that have been accumulated during the course of the marriage. What are they getting together to talk about? How do we equitably distribute this between the parties? Now, the
Yes.
court is going to look at that equitably. The court's position will be to put here in the States, to put them both in a fair and or equal position.
Equal position.
But a mediator, right? When I'm with the parties, who is equity up to? Who decides what is equitable? In court, the court can decide. If you can't agree in mediation, don't worry, you can reserve. I like to tell folks, it's okay if you don't agree. You can always reserve on this issue, and for determination by the court at trial. You can, please do not worry, you can let the court decide this issue. And now that's also reality checking, because people don't typically want to go in front of the court, right? But you tell them it's okay, but they will rule based on what the law is, right?
Yes.
Here in mediation, you can do other than that, right? There can be an unequal distribution of the property if the parties agree, if it makes sense to them. And now that's a slippery slope, however, right? We have to be really, really careful, because some people will be more powerful. Some people will be have a greater understanding of the law. Some people will be able to manipulate someone else. So the mediator's role is to make sure, right? We have to ensure that there's not an imbalance of power. We have to ensure that no one is coerced during mediation, that everyone's right to self-determination is being respected.
Yes.
And when we see that, the easy thing to do is just put them in separate rooms, and you're in caucus, and you can control that power dynamic and in that narrative. So let's assume that everyone is working well, right? If everyone is working well together, there are instances when someone will give up more, but willingly, right? That does happen. Parents, if we're talking where children are concerned, right?
Yes.
We will talk about child support, right? If the parents are splitting up, someone typically has to pay child support. Everyone pays child support, but if the children are living primarily with one of the parents, well, everyone has a responsibility to pay some child support, of course. But the party, you don't pay. You pay for the time you're not with the child, not for the time you're with the child, right? Because the other has to pay for all of their expenses, right? And so there must be some kind of compensation, for the children. So where child support is concerned, we're going to go by guidelines, right? But where something
Can I
like,
can I can I
please,
break you
because I
for
talk
2
way
minutes?
too much. Thank you.
Yes. No. It's not because you talk, because I will forget. You talked about guidelines. That's very
Sure.
important for us to know, because the law of mediation is coming up and we don't have any guidelines. In fact, I would, un, I mean, even I should not be quoted, but even the family law judges in our country do not have any specific guidelines when they decide about such cases. Excuse me. So when they decide about such cases, they don't have any specific guidelines. So this is where I hope that policymakers could listen to this, because this is very important. Once there are guidelines, it makes the life easier for a person who has to adhere to them. Because when parties are coming to these mediations, they are already emotionally compromised, they are not in their best senses, and they are not in those, their decision could be emotionally colored. Like you are saying, people are willing to give up whatever, whatever they should be legally getting. They are willing to give up because of obviously those emotions that are going on in their mind or what they are facing in their life, which maybe later on they regret. So that these policies, these guidelines are the ones that help the mediator. And if such guidelines are not available, so here comes the role, in my opinion, of an advocate or represent a party is represented by the advocate, so that they can at least see that there is fair and equitable distribution of funds, or if there is a dispute, even the commercial dispute, that things are happening at a fair, what we call a reasonable and fair logical perspective. So this is what I want to break you and bring this out from you, that how much policy matters help.
Hmm. Right. So guidelines. What do we have guidelines for? Um, when I say guidelines, so in this respect, I was talking about child support. Here in the states, if there are minor children, the court has jurisdiction over the money that will be paid to maintain children. So I like to tell parties, because they will argue about child support. We've agreed already. There's not going to be child support. Well, I'm sorry, but that money isn't mom's money. That money isn't dad's money. That money is the child's money. The court's interest is to ensure that the child is taken care of. The question that the court is concerned with, the guiding principle is best interest of the minor child. And so there are guidelines, right, to ensure that based on how do we arrive at those guidelines? When we talk to parents, I'm if you're getting a divorce, if there are minor children, we're going to talk about a parenting plan. If there's property at dispute, a marital settlement agreement. And so where the parenting plan is concerned, before I even talk about child support, I cannot, unless we have certain things have been discussed, addressed, and agreed to. And that is the first important thing is how many overnights in 365 days in a year, when is the child with the mother? When is the child with the father? And so the parties will say, oh, I want mom and dad, how do you envision time sharing? We call it time sharing. Custody is another, way you may hear of it. How do you envision the time sharing between the two of you? And they will say, I want 50-50, equal time with me, equal time with dad.
The spouse.
With the other, right? And now in Florida, it has become the standard is 50-50. But
Wonderful.
the law recognizes that each parent is entitled to 50-50. But of course, circumstances will make that that doesn't always work for any one of a number of reasons. So, but let's say that the parties, we go back and forth, and at the end of the day, they agree on either 50-50 or something in between. And case by case, it varies from family to family. But once I understand, once I take them through what is the regular ongoing time sharing, that's week in, week out during the school year, not including holidays, right? And then what are the holidays? We talk about those. And then we talk about summer when school is out. So we give them a parenting plan with the regular ongoing time sharing as well as the time sharing during the holidays.
So
So we
these,
will have covered.
sorry.
Go ahead.
So these are what are guidelines that are given to that a mediator should know as far as family, right?
Must know.
Right.
Right? It's so important for your mediator to be familiar with the laws and because if I can't calculate child support unless I know what the time sharing is,
Yes.
right? Because if I know what the time sharing is, then I know how many overnights mom and dad have each. First important component is of figuring out child support is the number of overnights. Once I know the number of overnights, Then mom and dad both, I have to know. That's why everyone must fill out a financial affidavit. We must have disclosure of all of the assets, of all of the incomes, right? And so, mom, how much do you make? A month gross before taxes. Dad, how much do you make a month gross before taxes? We then take that number and we input it into our guidelines. So now we know how many overnights they're with each child. Now we also know how much each parent is making, and then we'll take a couple of other things into account. Do they pay childcare on a monthly basis, right? Because that could be a large amount of money, right, to care for your children. Everyone doesn't have family that can take care of them. If there is that amount, we'll put that in there as well. And then how about health care, health insurance? Typically here, one
That
of the parents does both. So we take all of those numbers and then we
that
put them together, and that will give us, based
but
on,
that
I'm
is a
sorry to interrupt
huge
you.
amount. Sorry, I
No,
that is a huge amount of legal work. So here I sorry to interrupt you, and I
no, no, please,
because
please,
the
please.
procedure we um, so here I want to bring a lawyer, like,
Yeah,
because a mediator, like you said, pro se party. So here is the role of a lawyer coming up, that all these calculations, all these you know these legal work, this paperwork, is it done by a mediator or a lawyer also? A lawyer drafts
the
and looks at.
mediator is trained. So right now, this week, I'm training a new class of family mediators. And part of that training is recognizing what goes into calculating child support, understanding how to do so, and learning how to do it. Plain and simple, most of the people in my class are family attorneys as well. So it's easier for them. They're already familiar with it. What they have to learn is how to take off the advocate hat and how to put on the mediator hat. That takes a little, bit of work as well.
That
But
at
you
that
need to know how what it's helpful, right? So and there's a bias against non advocate mediators, right? Because they don't have
let's
the
let's talk to Vishal here.
please, I yes,
Vishal,
please.
Yes.
when he talks about to take off the advocate's hat and to don a mediator hat. Now that since you are an advocate and a mediator, and especially when you talk about when you have mediated cases on real estate, how important it is to take that hat out of you know switch over that role or transition of that role in a mediation.
I think it's very, because if we don't remove the head, then it becomes, we start thinking too adversarial, and the mediation won't happen properly. So the entire procedure will collapse. So we should just focus on the process. As a mediator, we should just focus on the process and not worry about the laws. But laws are there. We should be aware of it, because thing is, laws are, we should be aware because we should know what questions should we ask. Sometimes putting the right questions about law also will make them think, okay, so okay, we shouldn't do this, maybe we should settle, or we should come up with a proper settlement, something a realistic one. So that awareness is what a mediator or any lawyer should have. But having a lawyer attorney's hat as a mediator is not at all advisable, because it's going to be completely adversarial.
But at the same time, having an advocate on board, how easy it makes for a mediator, because the laws are being adhered to, or there is always, like Ty puts it, pro se parties are uncomfortable for him because they are not aware of the law. And if they are represented by their attorneys or their advocates who know the law, who are going to guide their clients about the background of law first and what is going to happen in the court, because a mediator obviously cannot speak about what is going to happen in the court, even though if he has to do the reality check, he has to do it in a suggestive form, not in the and that too in a question form and not in the advisory form. So when we talk about a lawyer's presence, here on the mediation table, and how the collaboration of a lawyer and a mediator, how effective it is for mediation. Let's bring that out for a common person perspective, how.
It would be, see, if the lawyer, the advocate who represents the party understands mediation, how it works, it's very easy. If he thinks it is again court or arbitration proceeding, then he's going to argue on the points.
Yes.
So if he understands from the client's interest, what his interests are, and we need to place his interest first, and then try. And one more great thing is, lawyers can actually manage expectations of the parties if they actually understand it. They significantly manage expectation. They will be thinking, oh, this much I can get settled if I come to meet. No. And one more thing is, advocates in India, as far as I know, people when they want to make a decision, they need someone to say yes. Need someone, okay, my decision is right. In that perspective, advocate who's representing that client, when they assist them, significant amount of settlements can happen through mediation. Significant.
Because, yes, very nicely put, Vishal. Because time, you would also agree that here the trust also makes a lot of difference. Because the client will definitely have a lot of trust on their attorney or their advocate who is representing their own interest. And if the advocate tells them, look, this much you will get in the court, and here in mediation you are getting this much, and this is going to be beneficial for you. Once that's what I think Vishal wanted to point out, that once that comes from an advocate, in the mediation, then things speed up. Because actually what you say is, this is dispute resolution. Legal system also is dispute resolution. That is going to take time, and that is going to be advisory, advocatory, or adjudicatory process. Here you have the decision in your hand, and so if you are if the parties are represented by their advocates, it will make a lot of difference. So Reena, what's your opinion about it? Let's ask her, because she's the new budding one.
Yes, Amar. So I would like to say that people are concerned with that they need someone to assure them of their decisions, what rightly Vishal said. So they have more trust in court, going to court rather than mediation and other dispute resolution,
Yes.
because they think that advocates are there to support them and will fight for their interest. And if they think that they will come for mediation without an advocate, and it makes difficult for them because they think they may lose more to the interest of their interest. And if there's an advocate present, he is there to check the viability of the proposal and protect the interest and everything the party, and do everything in the favor of the party, and to assure that yeah, you can do this and go for opt for this option. That also feels safe. The client feels safe and assured and comfortable that yeah, someone's here, so he can argue comfortably and also know that what I can expect and what all this can, where can this mediation session go. That's what I think.
Let me jump in for a quick second. I want
Yes,
to ask.
please.
Let me ask Vishal a question. And by the way, I think you're right in what you say, but I want to introduce something else, right? So, as you've served as mediator, right, and in those instances when you do have, and for the most part, do you have advocates on both sides? Do you have unrepresented parties sometimes?
Sometimes they are there. Then what we said, we ask, but it is not we ask whether do you want to represent, do you want to have an advocate on your side, because power image, so there is a power imbalance, because one party has. So as a mediator, I need to make sure that the power also balances.
That's right. That's
so
right.
What I do is I ask the party whether you can you represent, do you want me to suggest any advocates to represent you. So it's because power imbalances plays a major role. So I think
it does. It absolutely does. And so, but for the most part, it seems like you have advocates on both sides, right?
Yes.
So let me ask you, do you oftentimes have advocates who understand, excuse me, the mediation process, recognize it and appreciate it, and help their parties come to a good mediated, agreement that works for everybody? Does that happen often?
The thing is, what is the for a dispute to come into mediation, what happens is, if the if suppose both the sides are represented by advocates, if it is coming to mediation, then there is a possibility. But otherwise, what happens is, other side advocate stops there itself. They don't want to get into the mediation process. They somehow, so once if they're ready to get into mediation, then we are able to somehow give insights, and the party is also able to think loud.
Clearly.
And yeah.
What I was where I remember now that you mentioned, um, mediation is not court ordered, and because where you are, and because it's not court ordered, a lot of the mediations come from individuals who have advocates who recognize the validity of mediation. So then, actually, my questions was a bit misplaced, because where I was going was, so here, when you're ordered to go to mediation, right? So, and they come with an advocate, they've been ordered, however. So some of those advocates may not be advocates who recognize that they may want to go to trial, right? And so it can be problematic. It can be very tough for the mediator when you have advocates who are being very, very adversarial. It's helpful. It is nice when you have advocates who recognize and they take it to mediation, because then we're already starting off on the right foot, right? So it's a good that's a good problem to have. That ideally it. However, I'm hopeful in the future for your judiciary, for your judicial system in India, that mediation will become much more of a mandatory process. Now, when that happens, while that's a good thing, you're going to see more attorneys at issue in mediation. And so sometimes here, the attorneys are the problem. By the way, that's the exception. That's not the rule. For the most part, attorneys do a very good job. But sometimes the attorneys, mediations where attorneys are involved, can be very difficult because they can't stop being positional. They can't stop being adversarial. And so I will tell parties, or students or what have you, every mediation cannot reach agreement, should not reach agreement. Sometimes the role of mediation is to get the parties as far along as possible. There's so much miscommunication that goes on. Mediation, at the very least, can serve to dispel some of the communication and help the parties see where they need to go. Or, again, every mediation is unique and different. So, yes, advocates are really, really, really very important. And at this stage of where mediation is at, it seems in India, if the advocates are taking it to mediations because they believe in mediation, great. That's a wonderful thing. You need to get more advocates willing to see and that mediation is potentially a good place for their clients to resolve issues. Every issue can't be resolved in mediation, but when you have buy-in from advocates, it's quite helpful, because yes, people do look to their advocate. They don't know the law. That's why they got an advocate, is so that someone can give them the reassurance that they need. Absolutely. But it's more difficult when someone is unrepresented, because you can't give them legal advice. And now it's a harder thing to do, to help. Like, where do they get the who tells them it's okay to enter into this agreement? So the mediator, we have to honor self-determination. We have to empower the parties. And so you do it with the kinds of questions you ask, right? So if the mediator has an understanding of the law, they can ask, and I love that you said that, Vishal, they can ask the right kinds of questions to help the parties see that this may be, something in their interest. But it is helpful when there are advocates, right? Absolutely, it can be helpful when you have the right advocates.
And I love how Rina puts it, that to check the viability of the proposal. That was really awesome statement, because that's what I also wanted to say, that to check whether the proposal that is on the mediation table is actually legally viable or not. And that sometimes, quite often, because a mediator is focusing on the relationship part, on the emotional part, on to carrying the parties from their positions to the interest part, the legal viability of the agreement, if the attorney or the advocate is available on the table, he can check that. Because when we talk about, because Ty, you would appreciate that, in India we don't have all those that you were talking about, parenting plans. That's still not there. That concept is not there, that you know parents.
Not yet, hopefully. Hopefully it'll come.
Yes,
I think it's
I
okay.
also hope that, because that will make lot of easier and regularized. There's some policy that has to be adhered to, and that is made on for the benefit of the child in question. Because when the family is disintegrating, if we are talking about family mediation, or even when property laws are there, when the system is crumbling, so there has to be some guideline that has to be necessarily followed to, you know, the rule of law uh, is appreciated, and so
Let
that.
me, can I'd
Yes,
like to
please.
ask a quick
Yes,
question
please.
to Reina and Vishal, and that is, this is kind of what I was talking about before. What is equitable? Who decides what is equitable, right? When you say to make sure that an agreement is viable in court, in mediation, if the parties can do something other than what the court would order, right? Who decides then what is equitable? Who decides what is fair? The parties, right?
Yes.
Do they decide, or does the mediator decide?
The parties decide, because mediation settlement is a whole concept is about the parties willing to settle.
Yeah, right,
So I
right.
think so the parties only decides, okay, this is what we want to settle, and so it's completely the parties' perspective. And
So can that then agreement be actually unequal in with respect to something that the court would not order if it went there, right? But if the parties think, and so long as the parties are empowered, so long as the parties do see that something other than what would be ordered in court. So imagine, for instance, sometimes, let me go to family court, to family mediation. Sometimes things, I mean, there's a reason they're getting divorced, right? Things are not working out. And sometimes people just want to be done, for instance, right? And so I will tell my students, look, if somebody wants to give the farm away in a way that is unequal distribution, but they will, sometimes you'll hear things like, listen, I just want to be done. I don't want to deal with that crazy person anymore. I
Yeah.
don't I don't care. Am happy if I let them have it. I don't ever want to hear from them again. The court, that's not something the court would rule, but so long as they are happy with it, they are not that they're forced, right? Is that okay for the mediator to allow? Do you see what I'm saying?
yes, it's perfectly fine for the mediator, because the mediator is not the one who's going to uh,
Right.
decide what the parties want. We have to be okay, because if we start deciding what the parties should settle, then again it becomes adversarial.
That's right. That's right. Agreed. Agreed. But
So
it's counterintuitive, isn't it? The mediator has to uh, recognize that equity
recognize.
is the parties decide what is equitable, and so long as we see that, no, I think they're coming of of their own free will. I think that, yeah, okay, go ahead and do it, right? Because
But
we're always reading the temperature in the room, right? And so you'll know if something's wrong. But if they want to do something other than what the court would do, it's okay in mediation. It can happen in mediation. So you don't always need someone to say that, this is viable. If you know what I mean to say, like, you'll know when you know, FYI. It's just a nuance that sometimes is very, especially for new mediators, they're stuck on fair or what the court would rule. You don't need, sometimes you do, Sometimes you don't. It's case by case. It's art,
Yes.
not science. Forgive me.
Yes, this is where I wanted to ask you that there could be chances that, let's take about your example only, that somebody is totally giving up on their rights. This question came up in our mediators roundtable also, if you remember, that somebody is totally giving up. Then what will you do? And suddenly you feel that this is not right, and then after this mediation there's no, it's once the agreement is drafted, there's no going back on it. So here, I think there would be need of an attorney. A mediator should say, why don't you just go and talk to your attorney about it? Although you are deciding, it's your free will, you are deciding to give up everything. But why don't you just go and talk to your attorney? Because here the role of attorney is very important because like I said, it's emotional versus the logical, the viable, and in the long term, you know, and I mean they are doing, but they can just immediately sign. I give up everything. And later on, they realize, no, this is not correct. Then
I
what?
mean, potentially, but we can only. So I'm big on a mediator's instinct, right?
Yes.
How does a mediator become a good mediator? Experience. By doing it again and again and again, by seeing these things happen. And so you'll find yourselves in similar situations again and again and again, and each time you see it's always nuanced. It's a little different. You right, you can have two cases that on the judiciary docket looks the same, but the people, they have a funny way of making those cases very unique and very different from one another, because people can be crazy sometimes, right? And we see good people at their worst because I think Reina, I think you said it, they're emotional. They can't, it's very hard for them to be rational. The role of the mediator, what's great is we're that third party. We can see they come into mediation with blinders on, and they've been
Yes.
thinking about it, and they convince themselves, or people tell them, and it's very hard for them to see some other solution or something other than what they get in their heads, right? Like, my skills don't work very well here at home, but they work good outside for other people, right? We're
Yes.
able to introduce a third party perspective that it's hard for them to see. But we also have to know when they're coming to a good agreement. Yes, let me help them. And when to say, no, I don't necessarily know, right? Everybody, when there's a problem, we need to stop mediation, or like you said, Vishal, or maybe it was you, Sanal. Have you considered talking to an attorney? There are, we don't just let people come to agreement. We have to follow our instincts, and if I'm
Yes.
looking at the parties come to agreement, and if what they're doing makes sense, and I can see that everyone is vested, I love it, and I'm gonna, right, and the mediator can walk the parties through to agreement. We're like gatekeepers. We
Yes.
can help them unlock the
I
order
think
that
that
lets them move on.
So I think there comes the role of an attorney also, because that will be that the check, that do you really want to give up everything, that is the, and the
But the
time that.
mediator can, you don't always have to have an advocate
Okay.
there.
Okay.
You know
Okay.
what I mean to say? But the mediator has to really have a good handle and awareness of what's going on. So the experienced mediator can help overcome that, but not all the time, right? It's
Yes.
case by case.
One more thing, when you were talking, I remembered who drafts the agreement there. That legal help is required
Great
in
question.
drafting the agreement, because that also the role of an advocate or attorney comes in handy. So when we talk to Ty, after that we'll come to Vishal about it. Who drafts the agreement of the mediation agreement?
I wanted to ask Vishal in his mediations. Can we do it the other way around? I'd love to see, Vishal's perspective. Do you do it, or do the attorneys do it?
It's always better, it's preferable when advocates do it, because when both sides advocates are there, they know they protect each of the parties' interests and what is negotiated, and they make sure that the minute details are not missed out.
Right. Right. So there's different schools of thought here. Thank you for that, Vishal. When I was training, the person who trained me, their perspective was they adhered to the mediator should not write the agreement. I don't agree with that, but I might agree with that. I think it's case by case. What I mean by that, so now imagine 30 years from now, I hope that mediation becomes a vital part of the system, right? In India, right? And so when that happens, then the mediator, if you have an experienced mediator, how many agreements, for instance, Vishal, have you seen? Right? How many agreements have you written as an attorney, as an advocate? Plenty, right? So I would, yes, is that correct? I'm assuming that's correct.
Yes, absolutely. Every day.
Of course. They right, absolutely. So you do have the skills to write the agreement, right? And so imagine here in Florida 30 years later, attorneys come in, advocates, they come into mediation, and why do they choose mediators? Like, for instance, those mediators, Vishal, who bring cases to you, there's a reason that they bring them to you. They like you for, oh, I think Vishal's going to be good for this case. He has a good way with these kinds of cases, these kinds of people. Mediators are chosen by advocates for that very reason. They'll choose the one they think is best suited for this, right? And by the same token, they trust that mediator, because they're so experienced, is able to draft the agreements, right? And so oftentimes they will ask, they'll just, okay, Ty, so start drafting, and I will. But then when I draft, then I present it to both sides. And both sides, then, just as you were saying, they will review. And then they'll say, I'll go in with one side. And they'll say, okay, we love that. Look, we want to change this. We want to change this. We want to change this. And then I'll take that over to the other side and I'll show them. And they say, and we go back and forth on the language. And then we go back over. And then that process, it may take a few hours just to get to agreement. Then it will take an hour or two, depending on the complexity of the agreement, or more, to write the agreement. Then it will take an hour or two to go back and, okay, case by case, to get that agreement to the place where everyone's like, yes, I like it. Yes, I like it. And then now we have a final agreement. But by the same token, there are often, I will ask attorneys, advocates, please bring an agreement with you, because it's great when they do, because I don't stress. I'm not a stressor. But in mediation, when it comes time to type the agreement and everybody's waiting for you, that's when I stress, right? So it's helpful when advocates have agreements already prepared, but they don't do it often enough. So it can be appropriate for a mediator to draft an agreement, so long as the mediator is experienced enough, right? And they know that they're not inserting things that the parties haven't agreed to. They're putting the language, they're putting in the agreement what the parties have agreed to, but they also understand that, like, there is customary language that courts will use. And so we know what that language is. And then if the parties say, oh, but this issue, and based on our experience, because we've seen things so many times, we're able to put it in writing and say, let me ask you, if I were to write it, like, let's say we have an unrepresented party, right? So I'm going to be very careful about that's where you have to be really, really careful. But an experienced mediator, having seen it and done it so much, understands, practically speaking, this is typically what an agreement looks like in family court, for instance. Now, in civil mediations, I'm much more on I'm with Vishal. I would really prefer,
Yes.
and typically the attorneys, they want one, they will do it, because it's not as standard. It can be, but typically, no, they're gonna, and we don't file that with the court either. They do, but family matters are a little different. Those can be more standard sometimes, even though it's case by case. But my point is, the mediator can write the agreement. But at the end of the day, the advocate will review it with their client, right? But even with unrepresented parties, because if you think about it, they can't write the agreement. They just can't write the agreement. They don't know. Why should they know? Why would they want to know how to write an agreement? They haven't spent the time. They didn't go to law school. They don't do this every day. It's like any job, right? I can't do a mechanic's job. I can't do an airline pilot's job, just as they can't do my job. So it can be appropriate, but it's case by case with respect to writing the agreement.
Yes, and you talked about they represent the agreement to the court. That is also one aspect that I wanted to ask you. That has to be done by an attorney or advocate or the mediator. Who does it?
Forgive me, which part again? Say that
The,
again.
you talked about they are going to present the agreement to the court. That aspect we are not aware. So if you could
Got
just
you.
tell that,
I
because
got you.
who is
Sure,
going
of
to?
course.
Yeah, yeah.
So here, let's assume I meet with the parties, we come to a complete agreement, and I type up the agreement. Whether they type it or I type it, we have a complete agreement.
Yeah.
In family cases,
Yes.
the mediator will file it directly with the court, right?
Okay.
The parties, an attorney can do it as well, an advocate can do it as well, but we do it. I will send it directly to the court. As a Florida Supreme Court certified family mediator, I've been empowered. People can come to me, and the court will accept that agreement as valid because it comes to a Florida Supreme Court certified mediator.
Okay.
Um, and so I give it to the court, but the advocate has to take the clients through to final judgment. The mediator is not going to go in front of the judge and represent both parties and or in any way. No, but you can have unrepresented parties. So, but they can go in front of the advocate, in front of the judge on their own. They don't necessarily know how to do it and they don't like doing it. But if everything has been completed, the only thing, so when I help parties go through unrepresented parties go through a divorce, I let them know, listen, after I'm done, I cannot help you guys anymore. You can't call me when you don't know what to do in the courtroom. You can't call me because you don't know what papers to file. I can only help you come to agreement. I can file the agreement directly with the court if there's a case that's already been filed, and I can report to the court, we came to an agreement. I submit a mediator's report, but that's it. Why am I telling them that? Because typically they keep calling you. Oh, they didn't do this. Oh, and I tell them, listen, I can't talk to you about any. I may be your mediator again in the future. So I recommend to them, when we're done, if you come to complete agreement, find an attorney. One advocate can represent one of the parties, so long as there's nothing left to dispute. Everything has been completed. If that is the case, then you need someone to in an expeditious manner get them through to final judgment, to file it and get a date to go in front of the court, to get a final, or to get the order that orders a judge to order what the parties have agreed to, right? If you don't use an advocate, it's just, you can still do it on your own, but it will take a lot longer. And there's how do you file the paperwork? What do you type in the paperwork? People, they don't know that makes them nervous as well. So peace of mind is the advocate, right? But it's case by case. What if you only give them a partial agreement? What if they can't agree on everything? They're going to trial on those issues that they can't agree upon, and I will let them know, you should both consider getting an attorney at this point. You don't have to. However, when you get in front of the judge, when it's your turn, it's not like mediation and we take our time and I will hear everybody and I'm trying to be empathetic and I'm trying to build rapport. That's, the judge doesn't have time. The judge is going to say, okay, mom or dad, go. And you have to know what to say, how to say it, when to say it, what not to say. You're going to be nervous. Listen, you should really consider getting an attorney because they know how to do this. This is their job. But I will also let you know, this is when it takes longer. This is when it gets expensive. Litigation is very nerve-wracking and very costly. Now, sometimes that will be a reality checking tool to help them move forward, but sometimes it's not appropriate. Sometimes it's very appropriate for them to go to the judge. Sometimes they need the judiciary to make a decision. It's always better if they have an attorney at that time. But if we help them come to a complete agreement, it's great for an advocate to finish off the process, because it's peace of mind. It's worth every penny, and it can be done very, very fast. Like within 30 to 45 days of the filing, they can be. That's when you're divorced. That day, you can be done, and you don't have to worry about it, right? And I don't want to worry. I don't want to deal with them, because the pro se's, they don't know what's going. They will call you for everything, right? And I'm not your advocate. It's not appropriate. So if that answers the question, I go on and on and on.
Yes, yes, definitely that does. That does. That does. So this is what I really wanted to ask, because this brings out that role of an advocate, the role why attorneys would be required in a mediation, because this brings out for a common person that why advocates would be needed in a mediation process, and what is the clear distinct role of an advocate in a mediation process, because that makes a lot of difference in deciding for people, and how advocates and mediators can go hand in hand together, when the mediation process is there. So that makes a
When
lot.
that works, it's great, right? It's a
And if it
right.
doesn't,
Well, that's challenging, but often enough it does work, right? I mean, Vishal, when you're working well with the advocate to help the party get to where they need to get to, what a great experience that can be.
yes.
If especially advocates can understand what is mediation, they have a very important role: pre-mediation, during mediation, and post-mediation. All entire
Yes,
three places they play a significant
yes,
role.
Very
absolutely.
nicely put, Vishal. So
Yes, yes, yes.
pre-mediation, post-mediation, within the mediation. Very nicely put.
Can I ask Reina, what, so in listening to this, how do you, is it exciting to you? Are you seeing possibilities? What, as you hear myself and Vishal and Sonal, talk about this, you have some experience. I know you're a mediator. What are you seeing that, what do you think about it with respect to the future? And does it excite you? What based on what you're learning, what you've seen, and what we're talking about, what's your vision as the future, of the mediation process and advocacy where you live? What are you thinking about what we're saying?
Actually, it's very exciting, and I got a lot of knowledge today. Actually, I'm not exposed to mediation as much as you both have and Sonal. But like I think there should be a scope. The mediation should be like in law, and it should be like a necessity. Like parties nowadays think that uh, only the court is a solution for everything, for every
Mm,
disputes. And after that, they consider arbitration as the dispute resolution method. Mediation is not considered that important, but
mm,
I think it should be considered because uh, it's the parties in mediation, not the third person who decides the disputes what they want. So I think it should be uh, promoted uh, between the youth. And actually, I had a doubt I wanted to ask to you.
mm,
Maybe it's not related to the topic, but you mentioned, like you gave an example of a family mediation in which the uh, about the parenting policy and the child support money. If there's a case in which the child who doesn't want to live with one of his parents,
mm,
and you talked about the time dividing, like who wants to like what time should the child spend with the parents, both the parents.
mm.
So if there's a case that the child doesn't want because of any reason to live with the other parent, but the parent wants that he wants his child to live with him, then who represents the child interest in that case?
What a good question. That is. What a complicated question that is. And it goes to the heart of so many matters. My gosh. I'm going to try and keep it, simple. One, in mediation, we're not going to include in our negotiations the minor children. It's the parents who have to make these decisions. But these kinds of issues do come up, right? If we're talking about an older child, so here, a child reaches the age of majority when they're no longer eligible for child support at either 18 or when they graduate from high school, if up to 19, unless in some instances that child is dependent in because of a disability or something of that nature. Typically, child support ends at 18, 19, but it can go on in some rarer instances if you have, for instance, a child with a disability who can't work and and must be cared for by the parents for the rest of their life. That doesn't happen. You don't. That doesn't happen a lot. But regardless, there are so many reasons why the parties are in front of us and we're working with them, and some of those reasons can be, I mean, you can't make it up, and it's heartbreaking, and everybody isn't cut out to be a parent, let's just say. um, and so, but for the most part, it's the mediator and the parties and the advocates that are fighting these issues out. Children or collateral damage sometimes, but this is one of the reasons you're kind of hitting on one of the hearts. There's many hearts. Why does the court have the perspective best interest of the child? This is one of the reasons, right? Because it's in the best interest that the child not be with dad or not be with mom because of something that's going on that is in the best interest for the child, to not see it. Now, who is the voice of the child? What's refreshing, doesn't happen often enough, is when maybe they're getting a divorce, maybe they can't agree on everything, but where the child is concerned, they do a great job, and they can figure that part out, and then I'll help them with the money is where they don't agree or something of that nature. But things can get really ugly. I mean, you've heard plenty of stories, and children can be abused, and you can have parents with I mean, people can lose their parental rights because they abuse their children, or because they're criminals, or because there's drugs, or because they have mental health disorders. We could go on and on and on, and the things you hear in family mediation are oftentimes heartbreaking. And but sometimes there is a need for there's something going on, and then when you're listening to both sides, they will have different perspectives, they're blaming each other, and so the court um, can appoint someone to be the voice of the child. We call that a guardian ad litem. And so the guardian ad litem can be requested, a guardian ad litem can be appointed, and the guardian ad litem's role will be to visit with the child, to visit with the child's school, to visit with the mom, to visit with the dad, to go to their homes. And then they will write a report that the court typically will pay attention to the voice of the child, the guardian ad litem. Or we have agencies like DCF, Children Department of Children and Families. So what if someone is abusing a child? Happens far too often, and someone reports them. It can be a parent, it can be a school. We have we are mandatory reporters in right here in Florida, right? Um, and I have to tell everyone this when I'm giving an opening statement, right? When I'm talking about confidentiality, and then I will talk about the exceptions to confidentiality. What are the exceptions? If any unreported issues of child abuse, unreported issues of abuse of a vulnerable adult, disability, something of that nature, or ongoing illegal activity or fraud, those are, and there's a few more things, but the common ones that will break confidentiality, that gives a mediator the mandatory duty to file a report. And I have contacted Department of of Children and Families, I want to say 2 times in my 13 years. And so we have this duty, but again, and then we have dependency court. And dependency court is when the children have been taken away from the parents. But these are extreme cases, right? So that's on one hand, and those are really tough cases. But then just every family is unique, And so you will get these instances when someone says, yeah, but she doesn't want to live with him, or he doesn't want to live with mom. That can be a really tough place for the mediator. Well, he hasn't seen that child in years. He doesn't know how to be a good parent. He was an alcoholic. We need to make sure that that they can, in fact, timeshare, that they can be a good parent. And so, in instances like that, we're not going to bring the children in, because we don't want to traumatize them anymore. And although an advocate in a family case can petition the court for a child to be heard, it can happen, but that typically is, something is really going on. For the court to listen to a child, it's, it has to be sufficient, and it really has to rise to the level. But we can do things like something we call a step-up plan to reunify children with their parents again. You'll take baby steps, so to speak, right? And it's because the court recognizes that each parent has the right to spend time with their child, and they will do their best to give time to both parents, unless it can be shown that a parent should not, and that's a very high standard to overcome. And so, but how do you get the parents to agree on this? And so sometimes what we'll do is we'll say, well, what if there will be supervised time sharing that won't be overnight, and we'll do that in this manner or that manner for the first 2 months, and then the next 2 months we'll go to one overnight and one supervised visit, and the parents will meet here. They will exchange the child in this way. The supervised visitation shall take place from this time to this time. Specificity is also very important for a mediator. We don't give general language, because then people don't know what they'll do whatever they want. You want to be very, very specific so you can help them. But typically we don't hear the voice of the child, right? But we can, case by case. That's a great question, and it's so complicated, and it really depends on kind of what's going on. And that's one of the things that I'm a dad. So when I remember the first time that I had a domestic violence case, dad was incarcerated because he had murdered the child by throwing the child. I may start crying, I don't know, throwing the child repeatedly against a wall. And mom showed me pictures. I was a wreck, and I had to go down into the bowels of the courthouse, into the jail, to mediate with dad. I did not like this man, because I had seen what he had done, and I'm a father. I'm getting a little misty right now, but I was able to do my job. He had no idea that I thought he was a horrible man at all. And I was able to still, well, if you're in jail for doing that, you really don't have any parental rights anyway. But I was able to help. But the mediator will hear really heart-wrenching stories, and you do your best to help them. What a great question. I mean, we could go on and on and on and on, because there's so many different things that can happen.
Absolutely.
I love that
Thank you
question.
so
Let's
much.
schedule another just to talk about that, because
Sure.
wow, great. Listen, I want to say one more thing, if I may. The three of you, keep on doing what you're doing. You are making a difference, and the groundwork, the things you're doing, this that we're talking today, others coming after you will stand on your shoulders. You are laying the groundwork for the future vision of mediation in the country that you love, right? And the people that you live with, and in your individual communities. And you're all superheroes. And I know it sounds weird and hokey, when I speak of it like that, but mediators, what we do makes a difference. And because we can help parties draft agreements that the court will recognize and will order. So a mediator, in some ways, has power that is equivalent to judiciary power. Don't get me wrong, it's different. But what I mean to say is, we can help them get them through the door, just like a judge can. The judge has to ultimately rule it, but we can help walk them there. So that's a very powerful tool. And like Spider-Man says, with great power comes great responsibility. right? And so what we do makes a difference. You will, when you help a family, to your point, Rena, right, with those kinds of issues, and they come in and they're nervous or they're mad, and then we work with them and maybe 5 hours, 6 hours, 8 hours, maybe 2 sessions, 3 sessions, but we get them through it. And when you saw them initially, they're mad and they're angry. And then when you get them there, and then they say something to you like, thank you so much. Can I hug you? Can we pray with you? You made such a difference. It feels really, really good. I sleep really, really well at night. And I think I make a difference. And you guys are making a difference right now. You really, really, really are. And Raina, you have even more responsibility than the two of these advocate mediators. They're doing it now, right? And you're standing on their shoulders, but you have to do it better than the two of them do it. And you have to continue, right? So the three of you, please keep on doing what you're doing. You're making a difference in so many lives. Right now, what we're doing, right? Hopefully
Yes.
others are going to hear this. So keep
Yes.
it up. I'm so happy that we had this discussion today. Thank you.
Thank you so much. And I don't think we have more time just to thank you, because what you have concluded, we there's no words left. So any closing statements by anyone?
Agreed, right? Well done, everybody. Well done. That was so much fun too. I'm such a
Yes.
geek. I love doing that. I love talking about mediation. It's crazy.
Yes, I knew when I am going to do a session with Ty, it's going to last longer.
I wear that like a red badge of honor,
Yes,
Yes.
it is a red badge of honor. So Vishal, Reena, any closing comments from you guys?
I think Ty, Reena, and Sunil, thank you for this opportunity, and it was great with all of you to be. And we actually, Ty, it's just not three of us; it's all of us, all four of us, and many, many more people who are trying and to resolve. So such a great thing. We are all actually changing people's life.
Yes.
So we are really happy and proud about it, and we are
Yes.
going to still keep continuing what we are going to do.
Absolutely.
Thank you so much, Sonal, for having me here. And I really look forward to having more sessions like this in the future. And it was a great conversation with Ty and Vishal. And absolutely, Ty, I will work hard and give my best to
We're
do
counting
whatever
on
I
you.
can. Sure,
That's
yeah.
awesome.
Good.
That's awesome.
Thank you
I
so much.
love it.
So
Thank you
thank
all.
you, everyone. I'll just stop the recording now.